Hi, everyone. My name is LaFrancia Yates, and my team members are Doris Banks and Omar Nuruddin. And we are the Big Three. Our case fact pattern or our research topic is covenants not to compete, and our case question or research question is in Florida, Bob is laid off by Acme Widget Company. Bob, a widget salesman, had signed a contract that required that he not work for another widget company within 100 miles for the next 13 months. Superior Widget Company, which is located about 90 miles away, offers Bob a job. Should he take the job? The answer to our question is no for this presentation. We will explain the conclusion of our question as follows. For my part of the presentation, I will address the statute. Doris will expound on the case of Orkin Exterminating Company v. Tony A. Martin, and Omar will expound on the case of Graphic Business Systems Incorporated v. Rogue. First, I am going to type in covenants not to compete. And one of the questions that we were answering is covenants not to compete enforceable in Florida? And our answer is yes. Those contracts that would contain the covenants not to compete are, in fact, enforceable in Florida. But then we see here, when is covenant not to compete enforceable with Florida as our jurisdiction? And as you can see, the first uh, well, we're going to look at statues. So here we will click on statues and court rules. And as you see here, the first statue that comes up is Florida Statutes Annotated 542 dot 335, valid restraints of trade or commerce. And with West Florida Statutes Annotated, with Florida Statutes Annotated 542335, it reads as follows. Notwithstanding Section 542.18 and subsection 2, enforcement of contracts that restrict or prohibit competition during or after the term of restrictive covenants, so long as such contracts are reasonable in time, area, and line of business, is not prohibited in any action concerning enforcement of a restrictive covenant. A court shall not enforce restrictive covenant unless it is set forth in a writing signed by the person against whom enforcement is sought. The person seeking enforcement of a restrictive covenant shall plead and prove the existence of one or more legitimate business interests justifying the restrictive covenant. And below we see the term legitimate business interest, where it includes but not limited to those interests. And we go here, it says any restrictive covenant not supported by a legitimate business interest is unlawful and is void and unenforceable. Here we see in C, it says a person seeking enforcement of a restrictive covenant also shall plead and prove that a contractual specified restraint is reasonably necessary to protect the legitimate business interest or interest justifying the restriction. If a person seeking enforcement of the restrictive covenant establishes prima facie that the restraint of is reasonably necessary, the person opposing enforcement has the burden of establishing the contractual the contractually specified restraint is overboard, overlong, and otherwise not reasonably necessary to protect the established legitimate business interest or interests. If a contractually specified restraint is overboard, overlong, or otherwise not reasonably necessary to protect the legitimate business interests or interests, a court shall modify the restraint and grant only the relief reasonably necessary to protect such interest or interests. And we'll also take a look at number one, as it would pertain to Bob, who is a salesman. It says, in the case of a restrictive covenant sought to be enforced against a former employee, agent, or independent contractor, and not associated with the sale of all or part of, and we go down here to a court shall presume reasonable in time any restraint 6 months or less in duration, and shall presume unreasonable in time any restraint more than 2 years in duration. We'll go to two, where it says, in the case of a restrictive covenant sought to be enforced against a former distributor or dealer. And in my research, I went there because he's a salesman. I just kind of thought this may apply also. And it says franchisee and licensee of a trademark or service mark and not associated with the sale of all or part of, and then it shows you what that entails. It says a court shall presume reasonable in time any restraint 1 year or less in duration, and shall presume unreasonable in any time any restraint more than 3 years in duration. And taking a look at that statue, I also, as a part of my research, um, as specific to salesmen, uh, I typed in enforceability of restrictive covenant ancillary to employment contracts as affected by duration. Okay, because another one of our questions that we posed was duration after employment. So here we have enforceability of restrictive, covenant ancillary to employment contract as affected by duration of. And that is a secondary source, as you see over to the side that's selected. And here we go to, I am going to scroll down and we can find where it specifically has salesman, subsection 49 for a salesman. And we're going to, and forgive me, my page is not responding. Okay, and over to the side, um, I am going to go to state, and then I'm putting in state of Florida, and I will apply that as to locate the authority of the jurisdiction, um, as it pertains to the state of Florida. And as you see here, also in my research, where it shows inaction by former employer to enforce covenant not to compete, which provided that salesman employee could not compete for period of 2 years after termination of employment within city or within area encompassed by a 75-mile radius from city, covenant not to compete appeared prima facie reasonable both in time and area, and granting of temporary injunction was warranted. And this is where, in my research, we got the cases of Graphic Business Systems Incorporated v. Rogue, and also Orkin, um, as you can see, Orkin Exterminating Company v. Walker. And that is my part of the presentation, regarding the statutes, and also secondary sources, where in my research the cases were found. Thank you.
Hello, I'm Doris Banks, and I am presenting my screencast-o-matic video with the group I'm a part of, and we call ourselves the Big Three. And my partners slash teammates are LaFran and Omar. My portion of our group assignment slash presentation is to speak on an opinion which is a primary authority that involves a covenant not to compete. Our case assignment reads as follows. In Florida, Bob is laid off by Acme Widget Company. Bob, a widget salesman, had signed a contract that required that he not work for another widget company within 100 miles for the next 13 months. Superior Widget Company, which is located about 90 miles away, offers Bob a job. So the question is, should he take the job, or did we need any more facts for this case assignment? Well, during our team collaboration, we have discussed and reviewed numerous statutes and opinion cases, and I will be presenting the following opinion, which is the Orkin Exterminating Company versus Martin out of the District Court of Appeal of Florida in the 3rd District. back from 1987. So I will go ahead and click this case and let's open it up. And there it is, Orkin Exterminating Company versus Tony A. Martin. So I'll go straight to the opinion. And I have a few of the opinion paragraphs highlighted for my own records. So I'll go ahead and start reading the case. Orkin appeals a temporary injunction entered against a former employee pursuant to a covenant not to compete. We reverse. When Orkin employed Martin, they entered into a written contract which contained a covenant not to compete. The covenant restricted Martin from engaging in the pest control business anywhere in Dade County for 2 years following his termination of employment. Martin voluntarily terminated his employment and he began working in Dade Company with one of Orkin's competitors. Orkin sued and the trial court entered an injunction restricting Martin from engaging in the pest control business within the territory which he had worked when employed by Orkin. This territorial restriction materially reduced the geographic restriction agreed to in the employment contract. Orkin appeals the limitation imposed by the trial court on the geographic area covered by the injunction. Well, in our group collaboration for this particular case, we discussed a few questions for review according to my research of the case. Our first question was, what is the duration after employment? So I went ahead and decided to look up what duration means. And duration means the time during which something continues. Well, according to the facts, Bob entered a signed contract with the Acme Widget Company for the duration of 13 months. Per the Orkin versus Martin case, Acme can have a temporary injunction entered against Bob because the covenant restricted Bob from working for another widget company within 100 miles for the next 13 months, while the superior widget company was located 90 miles away. The injunction can also include restricting our client Bob from engaging in business within the territory which he had worked when employed by Acme Widget Company. And that's just right here. That just shows right here in this paragraph where I have highlighted in orange, and it talks about that what I just read. And so I go down to the second paragraph that is highlighted in green, and I'll start talking about that in reference to the research and under the duration. Non-competition provisions in employment contracts have been enforced when the duration of the restriction and the area within which the employee cannot compete is reasonable. Well, the Orkin case further talks about reasonable. So we'll go and just show what reasonable is that they talk about. Reasonable is determined by considering the individual facts of each case. And we read that right here, reasonable is determined by considering the individual facts of each case. And in our client's case for Bob, we have a duration period of 13 months within that radius of 100 miles. And then it talks a little bit more about the restrictions And it says restrictions such as those contained in the subject covenant are reasonable on their face and have generally been enforced. And all of this in this area, it is in this green area as well, right here. So that leads us to our next question. Is a covenant not to compete enforceable? Yes, it is according to a Florida statute, and I will go to that Florida statute, which is 542.335, and I had already entered it in my search earlier, and it'll be coming up shortly. And I'll just read that because my partner friend, she will further expand on this statute, but I'll just read this portion for this case. Just for the statute purposes. Okay, here we have our statute. Notwithstanding 542.18 in subsection 2, enforcement of contracts that restrict or prohibit competition during or after the term of restricted covenants, so long as such contracts are reasonable in time, area, and line of business, is not prohibited in any action concerning enforcement of a restrictive covenant. So this leads us to the question at hand. Should Bob take the job? According to our research and our court opinions and statutes, no, Bob should not take the job. And this concludes my portion of the opinion based upon covenant not to compete. Thank you very much.
Hello, I'm Omar Nuruddin, and I'm going to be presenting my part of our jurisdiction and topic. I'm going to be going over an opinion for the covenant not to compete in Florida. I will be going over the opinion of Graphic Business Business Systems Industries v. Rogue. I'm going to be going down straight to the opinion. And as to the opinion, it says right here, Graphic is engaged in the sale of businesses, forms, which includes the brokering of the forms from the printer to the customer. In February of 1979, Rogue went to work for Graphic as a salesman. At the time, he signed an employment contract which provided in part as follows: employee as an endorsement to employer to employee, and upon the considerations in this contract set forth and hereby promises and agrees that he will not directly or indirectly engage in said business forms. Business in the following described territory for a period of 2 years from and after termination of his employment, and that he will not directly or indirectly for himself or in connection with any person, firm, or corporation come into competition with employer within the following described territory, and the employee will not in any manner directly or indirectly interfere or attempt to interfere with the business, goodwill, trade, customers, or employees of employer, or with anyone dealing with this employer. The territory shall encompass the geographic area in which the accounts of employer are being served by employee, and shall include all accounts serviced by employee during the tenure of his employment, and the area shall be the city of Tampa and also a radius of 75 miles from Tampa, Florida, but not to exceed the territory previously serviced by employee Lynn Rogue, and shall include in any accounts signed salesmen outside of the boundary, While employed by Graphic, Rogue's territory encompassed Hillsborough and Pinellas counties. Rogue voluntarily terminated his employment with Graphic on December 3rd, 1981. Thereafter, according to Graphic, Rogue went to work for a competitor, Suncast Business Systems Industry, which has an office in Clearwater. So, in our case, Bob worked for Acme Wage Company as a salesman as well, and had signed a contract that required him not to work for another widget company within 100 miles for the next 13 months. But later on, he got an offer for a company called Superior Widget Company, which is only 90 miles away. Now, in this case over here, it shows that with the salesman signing a contract of the covenant not to compete, that he would be limited to 2 years in the radius of 75 miles from the city, but not to exceed territory previously serviced by salesmen. As to answer the 3 questions that we have to this case is that duration of after employment. Question: what is the duration after the employment? Now, as for Bob, when he signed his contract, it stated that he could not work for another widget company for another 13 months. And if you compare it to this case, it said for a period of 2 years after termination of his employment. With our second question being the distance of the previous employer. With Bob, when he signed the contract, he could not work within 100 miles, but the company that gave him the offer is only 90 miles away. So that competes. With the third question being is covenant not to compete enforceable in Florida? Which it is, because if you look at under here being, it is covenant not to compete enforceable in Florida. Now, with the District Court of Appeal of Florida, the Second District, stating in the opinion, the agreement not to compete signed by Rogue appears reasonable both in time and area. There is substantial evidence to show that Rogue was violating the agreement by working for one of the graphics competitors with the prescribed area. Now, with stating that, it means that covenant not to compete is actually enforceable in the state of Florida, which also brings to a statute. Should Bob take the job? No, he should not. With presenting all the facts that we gave, he should not take the job because covenant not to compete is enforceable and that the contract does sound reasonable